Hey, estate planning attorney Paul Rabalais here, and in this video we're going to talk about 8 things that you should not put in your will. All right, sometimes people die and the survivors bring in the will, and I read over the will and I'm like, why in the world was this written into the will? And sometimes we see stuff that shouldn't be in there in wills that are typed up, notarized, and witnessed. They were written by lawyers, and we go, why is that provision in the will? But in many cases, people, as in my state of Louisiana, sometimes people write their own will. They do it in their handwriting. It's called an holographic will. In other states, it's called a holographic will. About 25 states permit people to handwrite their own wills. No notary, no witness requirement. And then sometimes in these holographic wills, we see people seem to want to just vomit stuff on the paper, and they're writing and they're writing and they're writing and they're writing all kinds of stuff that shouldn't be in the will. So I'm going to go through kind of 8 things that really shouldn't be in your will. Number 1 is funeral arrangements. It's probably not a good idea to pass away. Your family buries you 6 feet underground, and then a week later they open up your will, and in your will you said you wanted to be cremated. Then the family may have a decision to make. Do we dig them up? So there's a right way and a wrong way to document your funeral wishes anyway, whether it's informally communicating to those family members, legally putting a separate document in writing as to who has the right to make all of those burial and funeral decisions, but putting it in the will, because the will isn't reviewed until sometimes weeks after somebody dies, isn't the place to do it. Number 2, organ donation. You can save lives. You can save multiple lives by being an organ donor. I'm very involved in our Louisiana Organ Procurement Agency. I've seen it. Seen people who are living today because of organ donation. They would not be living today if it were not for organ donation. But putting the fact that you want to be an organ donor in your will, that's a mistake. So there is a proper way to document being an organ donor, and in my state you can do it online. You can do it at the Office of Motor Vehicles. Put the little red heart on your driver's license. But putting it in your will is not the place to put your organ donation, desires or wishes. Again, same thing. You pass away, you've got organs that could be used by other people. You could be saving lives, but you get cremated, you get buried. Week later, they open the will. I want to be an organ donor. Oops, too late. So make sure you do that the right way. Number 3. Designating who gets your IRA or your individual retirement account. We see this not only in the holographic wills where people don't know any better, but sometimes we see this in the wills drafted by lawyers, where there's a provision in the will that says, and for some people, their IRA is their single largest financial asset. Some people have, they have a home that's worth $200,000. They have a checking account with $10,000 in it, and they have an IRA worth $1 million because they built it up over so many years working for a company, having a 401k. They retired, rolled it over to an IRA. That's by far their largest asset. And in their will, they mistakenly put, I leave my IRA to Fred. But 25 years earlier, when they set up the IRA account on the beneficiary designation form, they don't remember any of this because it was 25 years ago. But as a formality in setting up the account, they had to designate a beneficiary, and they put Darla as the beneficiary 25 years ago. Well, they die. Who gets the money? Darla gets the money because she was the designated beneficiary. What it states in the will about where his IRA goes means nothing. Now, I guess there's an asterisk there or an exception if on the IRA, which it never does and never should, if on the IRA beneficiary designation form it designates the estate as the beneficiary, which there's no reason to do that, particularly no tax reason to do that, then it flows through the estate and goes to the heirs named in the will. But that's the only time where the will may impact where an IRA might go. Make sure you designate beneficiaries on your IRA. Number 4, your life support machine decisions. So many people come in and tell me, Paul, look, if there's no hope, if I'm a vegetable and I'm just hooked up to machines. I don't want to see my family suffer. I don't want to incur a lot of expense. If there's no chance that I can come out of this and have any quality of life, let me go, take me off the machines. But again, putting it in the will, that's not the place to do it. It's the living will declaration. It's a separate instrument. When you're admitted to a hospital, you're likely to be asked, do you have a living will? Maybe the word will shouldn't be in living will, because too many people confuse living will with last will, and so they just think it's all the same thing. But anyway, your life support machine's decisions should be documented in your living will or living will declaration, not your last will or last will and testament. Number 5. Now, many people have gone to attorneys and set up trusts or living trust. And they do that, many of them do it because they don't want their survivors, their family members, to have to go through the court and attorney involvement of probate when they die. So they put assets in their trust. Let's say they put their home and their stock account in their trust. And then in their will, they say, I want all my stock to go to Samantha. And then they die, and guess who doesn't get the stock? Samantha, because the trust instrument controls where the trust assets go. So the will only controls the assets that are in your name when you die. If you've moved assets into a trust, the trust really replaces the will, and the trust instrument determines who gets those trust assets when you die. So who gets the stock is based on the terms of the trust. Now, maybe in your trust you said, when I die, I want my stock to go to Samantha, and you put that in the appropriate way in the trust instrument, then Samantha would get it. But if the trust says, when I die, the trust assets go to my 3 children equally, that stock's going to go to the 3 children equally. So be conscious of the fact that your trust determines where the trust assets go. Number 6, assets in an LLC. We see this a lot. Many people who own rental property, for example, they own those properties in an LLC, a limited liability company, in order to avoid personal liability for debts of the LLC. And let's say they own 7 pieces of property in their one LLC, and then in their will they say, I want property ABC Sesame Street to go to this person, I want CDF Sesame Street to go to this person, but all those properties are tied into that one LLC. And now they could donate or bequeath membership interests in their LLC to other parties, but they can't really designate individual properties that are all encompassed within that LLC to others. Perhaps if they have 7 different properties in one LLC and they want those properties to go to 7 different people, perhaps they should remove those properties from the one LLC, create 7 different LLCs, and bequeath their membership interest in each of those different 7 LLCs to 7 different people. I know that sounds complicated, but you got to get it right because it's a mess when it's messy. Okay, and number 7, again, a really big one for the oligraphic wills, the reasons why you left a bequest. There's a right and a wrong way to do that, but probably in your will is not the right place just to vomit, I'm leaving $25,000 to my granddaughter, Ella. Great for you, great for Ella. And then we see in the will, and I'm leaving it to Ella because she calls me once a week. When I was sick, she picked me up McDonald's and brought it to my house. And then every Christmas and Mother's Day, she comes and visits me. And my other grandchildren, they only call maybe once a month. And they only came and visited me 2 years ago on Mother's Day and not on Valentine's Day. So that's why I'm leaving. I'm like, oh man, geez, there's no place in the will for that. Now, if you really want to communicate that stuff, maybe in a separate writing, a separate communication that doesn't have to get filed at the courthouse, put into the court filing and all of that. So again, we see a lot of that. People feel like they've got to just go on in their oligraphic wills. That's not the place to do it. And then number 8, similar to the IRAs that I discussed in number 3, number 8 is the life insurance and annuities. You bought life insurance 40 years ago, and you have absolutely no recollection that you designated beneficiaries when you acquired the life insurance policy. But now that life insurance is $200,000, and in your will you say, I want my grandson Mark to get my $200,000 life insurance policy. Good job, Mark. But then 40 years ago, or 30 years ago, or 10 years ago, when you acquired the life insurance policy, you designated at the time you wanted Mary to get the life insurance. So she's the one listed as the designated beneficiary in your life insurance. I think most people know this, but Mary's going to get that life insurance because she's the one designated as the beneficiary on the life insurance beneficiary designation form, even though in your will you said you wanted so and some other person to get your life insurance proceeds. Same thing applies with annuities. Annuities and life insurance, all sold by insurance companies. All those have beneficiary designations. Kind of like the IRA, there is this exception when the estate is designated as the beneficiary, then what's in the will does have impact on where those life insurance proceeds, annuity proceeds, or IRA proceeds may go. All right, so that's a quickie on 8 different things that you shouldn't include in your will. Make sure you turn the like button from gray to blue. If you haven't already subscribed, hit the notification bell. That way you won't miss anything. I'm taking off. I'm in my office right now. I'm going home. We'll see you next time. Take care.